In Florida right now, there's breaking news in the George Zimmerman trial. The court is compiling a list of evidence for the jurors. They just asked for it only moments ago, nearly 2.5 hours into their deliberations. The 6 women are trying to sort out what really happened on the night of Zimmerman's deadly confrontation with 17-year-old Trayvon Martin. Jurors will decide whether Zimmerman is guilty of second-degree murder or the lesser charge of manslaughter, or whether he acted in self-defense and can walk away from this trial a free man. The defense attorney, Mark O'Mara, spent more than 3 hours delivering his closing arguments today. He told the jurors that Zimmerman is, in his words, completely innocent, but he stressed that they only need to have reasonable doubt about his guilt to acquit him. And he hit at the heart of the self-defense claim, suggesting that Trayvon Martin didn't have a gun, but he did have a weapon.
That's cement. That is a sidewalk. And that is not an unarmed teenager with nothing but Skittles trying to get home. That was somebody who used the availability of dangerous items from his fist to the concrete to cause great bodily injury. Not that it's necessary for self-defense, but great bodily injury against George Zimmerman. And the suggestion by the state that that's not a weapon, that that can't hurt somebody, that that can't cause great bodily injury is disgusting.
The prosecutor, John Guy, had the last word delivering the state's rebuttal. He argued that Zimmerman acted, in his words, with ill will or hatred, the requirement for a second-degree murder conviction.
When a grown man, frustrated, angry, with hate in his heart, gets out of his car with a loaded gun and follows a child, a stranger, in the dark, and shoots him through his heart. What is that? Is that nothing? That's not anything? Is that where we are? That's nothing? Well, that's not his call, and that's not my call. That's your call.
And right now, let's go into the courtroom because the judge has reconvened the attorneys. You see them over there. They're going over a list of the inventory of all the evidence that was presented during the course of the 3 weeks of this trial. The jury wants that inventory. They want a list. They want a number of each item, each piece of evidence, so they can review it methodically, very, very carefully. Jeffrey Toobin is with us. Martin Savage has been covering this trial for us. He's with us as well. Jeffrey, what do you make of this first request, this first question from these 6 women of the jury?
It's actually a pretty typical first question for deliberations in a pretty complicated case. I would guess that there are probably close to 100 exhibits in this case, and the jury wants to be able to take a look at what's what. These are fairly common questions, as I say. Sometimes jurors ask for pens and paper. They ask for a blackboard, a whiteboard. This is how jurors get organized, and it would not be a surprise at a later point to have the jurors ask to see some of the exhibits on the list that they're going to get shortly.
What's surprising to me, and let me bring Sonny Hostin and Martini James into this conversation as well. Sonny, let me go to you. Surprising a bit to me to see that they don't have this already ready, a list, an inventory of the evidence. Wouldn't that be something that they would have ready to go? Why do they have to do it in the middle of deliberations?
Yeah, I mean, I certainly always had an inventory list of my evidence. I'm sure Jeff did as well, perhaps Mark. Sometimes you don't think you need it. Sometimes it's just not done. But I was surprised as well. I will say this. A lot of people around the courthouse are saying, you know, verdict tonight, verdict tonight. That has never been my impression. But the fact that they wanted the inventory list so they could see what evidence was in there and they could sort of pick and choose by number tells me what I thought. This is a methodical jury. They're going to look at everything.
And what does it say to you, Mark?
Yeah, I agree with that. I think that they can look at whatever they want to look at and don't have
Hold
to
on a
look at
second,
anything
Mark.
if
Hold
they
on a
choose to
second.
do
The
that.
judge,
Objections
Deborah
to,
Nelson, is
6
speaking.
copies being provided to them from the Deputy Jarvis, or do you want me to bring them in the courtroom and
We're
give it to
fine
them?
with it being delivered, Your Honor.
We agree, Your Honor.
Okay, thank you. We'll go ahead and have those 6 copies delivered, and we'll be in recess.
We
Yes.
should have asked this before, so we don't need it right away, but just for our purposes, can we get a couple of copies? I think we'll probably want one of what was sent to them. Great. Doesn't need to be right away. Next time you have to make copies of something. That'd be good.
Okay, thank you. Court will be in recess.
There she is, Deborah Nelson, the judge in this case. She's been doing a very, very significant job as the judge in this case. But let me go back to Mark Nijame. So the jurors, the six members of the jury, they're going to get a list of the inventory, the attorneys for both sides, the prosecution and the defense. They'll get the same list. You were saying to us, what, if anything, this request from the jury for an inventory, does it give us a tip, a signal, a hint of what's going on behind closed doors?
I really agree with Sonny on this. I think it's just an efficient way for them to hunt and peck for those items that they, in fact, want to go through. I do think it's a very studied jury. I think most of them were taking, in fact, I don't think, most of them were taking notes throughout. One in particular took probably as accurate as any court reporter in there. She was writing nonstop throughout this whole thing. I think what the jurors are going to do is try to align themselves and see if they all can, at some point, agree with the evidence. If there's areas of dispute, they'll go through their individual notes. They'll go ahead and figure out where their disagreements are, and then they'll reach a consensus. That way, they're at least dealing with common facts and common evidence, or a common agreement on the evidence, so that they can start working towards, through their deliberations, towards a resolution. I think if there's a general consensus, we will have a quicker verdict. I think if there's a disagreement, somebody wants acquittal, somebody wants manslaughter, that's where the back and forth will go as they work through everything. If there's a general consensus, I think we could get an earlier one. But if we don't see a general consensus, I think we could be here for a bit longer, because there is a lot of issues, a lot of passion, and a lot of disagreements over how these facts unfolded for them to consider and then to have to agree to. Because remember, it's got to be a unanimous jury.
It's got to be 6-0, either guilty or not guilty. Martin Savage, you've been watching this from the beginning. There's a game plan, assuming an hour from now or 3 hours from now or tomorrow or Sunday, they've got a verdict. They've got a game plan, how they announce it, what they go through. It's pretty specific.
It is. I mean, we are told that we'll get at least, 1 hour heads up. Now, that is a little bit different when it comes to today. The heads up could be a little bit shorter because of, we've just started and the fact that everybody is right here and present. But the idea is that there would be a notification and that at least 1 hour heads up would be granted. And then, of course, everyone, including the media, would be back in the courtroom there waiting to hear what the verdict. I'd be interested from those that are, the expert analysis here is, I would have assumed that once that jury went back there, they would have taken some sort of initial, so what do you think? How about a quick vote? Are we all in agreement? And that if that has happened, then now we find out they're not all in agreement, and there's only 6 of them. So it appears now they're going to have to go over everything. But I'll leave it to the analysts on that.
Yeah, a lot of times the jurors, if there's 8 or 12 jurors or whatever, it takes them a little bit longer than 6 jurors may or may not. You never know. There could be a 6-0 decision one way or another. There could be 3-3, 5-1. They got to be unanimous either way, guilty or not guilty. Everyone stand by. Big gestures, strong emotions today, how the prosecution played on jurors' sympathies and the defense tried to play them down. Also, first on CNN, the defense attorney, Mark O'Mara, answers a driving question during this trial. Is George Zimmerman a racist? Martin Savage's interview with Mark O'Mara, that's coming up as well.
An element or ingredient to Miss Fulton having just lost her son.